Well, welcome everybody to our webinar today on advanced care planning, making your wishes known. Our speakers for today, myself, Melinda Merk, I'm a principal in the Wills Trust and Estates group at McCandlish Lillard, and my partner Elizabeth Gray, who's also a principal in our Wills Trust and Estates group. And we have our special speaker, Megan Descutner. And Megan, we want to give you just a few minutes to introduce yourself and tell us more about what you do as an owner and care manager of Golden Pond ElderCare Strategies.
So I'm a nurse care manager caring for aging adults and people, individuals with disabilities. And my company is Golden Pond ElderCare Strategies. We're comprised of an interdisciplinary team, and together we're professionals who work as a team to provide comprehensive care for our clients. And we often refer to elder law attorneys, and we work with Liz and Melinda quite often.
Great, thank you, Megan. So just a little bit about National Healthcare Decisions Day, and then we'll get into the agenda and into the material. The official day for National Healthcare Decisions Day was April 16th, which coincides coincidentally with April 15th. So we did want to give some people a break after that. And so we're hosting our webinar today. An interesting background, National Healthcare Decisions Day was actually started by a Virginia healthcare law attorney, Nathan Camp. He's still in practice. He started this initiative in 2006. As a healthcare law attorney, he advised primarily healthcare providers and hospitals and other medical institutions, and they were finding that with a lot of their patients who were in critical care and suffering from terminal conditions did not have any advance medical directive and had not made their wishes known to their family and other loved ones. And so Nathan Camp started this initiative, and all of the hospitals around the Commonwealth of Virginia participated. And the initiative went national starting in 2008. So our purpose today and the purpose of National Healthcare Decisions Day is to raise awareness and help to educate everyone about the importance of advanced care planning and most importantly to start the conversation, talk to your family, your loved ones, communicate what your wishes are with regard to your healthcare decisions and other end-of-life treatment, and to document those wishes in an advanced medical directive. And so we've put a link here to where you can get more information and other resources on this very important initiative. So our agenda today, we're just going to walk through some of the myths and fears about healthcare decision making. We're going to get into some of them, the legal definitions and considerations. We're going to talk about the importance and how you go about selecting a healthcare agent, and then getting down more into the practicalities of how to talk to the healthcare providers and actually, and when you're serving as a healthcare agent, how to actually make these what can be very difficult healthcare decisions, particularly with regard to end-of-life decision making. Any questions that you all may have, please post them in the chat, and we will be saving time towards the end of the presentation to answer your questions, and Liz will be monitoring the chats as your questions come in. And as I said, we are recording today's presentation, and we will be making that recording available on our, along with the slides on our firm's website. Megan, now I'm going to turn it over to you to talk a bit more about some of the myths and fears about this topic and advanced care planning, and more importantly, what can happen when you don't do anything in advance, and why it's so important to talk about this important topic.
Well, let me start with a scary story. So a colleague shared with me a very sad situation that is the exact reason why it's important to document your wishes and not just leave it up to someone else that you think loves you and will make a good decision on your behalf, because it sometimes is taken out of everyone's hands. So Vicky had a grandmother named Rose, who she dearly loved, and Rose was fiercely independent, and she did very well on her own in her own home for a long time. Eventually, she started having less energy and needed more help. And Vicky and her husband, Rick, got very involved. Eventually, Rose had a stroke, and they took her into their own home, and they took care of her extensively for a very long time, knew her well, dearly loved her. She confided in them her wishes, including end-of-life types of wishes. Well, Rose had been estranged from her son for a long time. And at the point where Rose ended up in the hospital and in the ICU, her son got wind of it. And he came and wanted information and inserted himself into the situation. And because it wasn't in writing that Vicky was the power of attorney, even though the doctors knew that, that there was the relationship, there was the trust that existed there and had for years, the son had more authority under the law to make the decisions. And they not only got pushed out of the decision-making with the healthcare team, but Vicky and Rick, their visiting time was really limited because the son was so convinced that they could affect things. So his goal was to deal with this estrangement, re-engage with his mother, make up for lost time. So he asked for absolutely everything to be done because he was hoping for that moment that they could make things right again. But he started way too late, and she had to go through the ventilator and the dialysis and everything that goes along with a body that just isn't functioning anymore. And the granddaughter and her husband were bereft because they never wanted her to have to go through that, because she didn't want to go through that. And they weren't able to enact her final wishes. And of course, the son never got the reunion that he wanted either. So, I mean, that's just a really frightening story for all of us, even though there are people around us, and even the person you might choose as your agent may know what you want, but circumstances sometimes overtake. And so it's really important to have it documented as well. Liz, you had some ideas about the myths too, right?
Well, I was going to tell you about my situation that I was with my aunt when she was in the hospital. She was terminal. She was in a lot of pain. And my cousins, who are both attorneys, were not named. My aunt never did an advance medical directive. And she was in pain. And my cousins were saying, "Oh, you're going to be fine. You're going to be fine. Just try this treatment. You're going to be fine." And she was not going to be fine, and she was not going to recover. So I got the doctor to come in and talk to them, and we finally got them to do what they needed to do. And I just thought it was really sad, because I'm sure my aunt did not want to try any more treatments. She just wanted comfort care and to say goodbye, and she didn't get that. The other thing that happened is that nobody in my family will pick me as an agent, because they call me Dr. Death, because I was encouraging them to pull the plug, but that's beside the point.
Yeah, and I think that's again the importance of why it's called an advance medical directive. It's something that you document in advance. Hopefully, you communicate it to your family members, because as this slide says, I mean, when the crisis occurs and your loved ones and other family members are faced with trying to guess basically at what you may have wanted, when it's already an emotional, clearly an emotional situation, that's the best gift that you can give them, is to have in advance document what your wishes are, so that it's clear. Because as we'll get into on the next slide, if you don't designate, if you don't have advanced medical directive and durable healthcare power of attorney, Virginia law decides who your decision makers are, and that may not be the person that you would have chosen. And so, Liz, do you want to go over this slide?
So you don't have an advanced medical directive. The Virginia Code has a descending order of people that can make those decisions. The first one is a court-appointed guardian. And that person, the court-appointed guardian, trumps a spouse, except for a divorce action, even if the divorce is not final. And then adult children. Now, if there's 2 or more children and they can't decide, the code says that the doctor can use the majority decision. But I just don't think a doctor would do that. My guess is that if there's controversy or disagreement, discord amongst the family members, doctor isn't doing anything. I don't know, Megan, if that's what you see happen when there's family disputes about this or not.
I think that the doctors worry about legal action, and so would do the positive thing, like the treatment versus withholding treatment.
And after adult child comes parent, adult sibling. Number 6 is any other blood relative in descending order. So your distant cousin or a niece or nephew. Number 7 is a little disturbing in my mind. So you can't make these decisions if it involves withholding or withdrawing life-prolonging procedures. But any adult currently involved in the care of the patient who's exhibited special care and concern for the patient and is familiar with the patient's religious beliefs and basic values can make that decision. And then after that is a patient care consulting committee. But it sort of bothers me that any adult, and who's to say somebody has your preferences known and your religious beliefs and stuff like that, can go in and say, if there's not these other people, this is what he or she would want. We've never seen, or I haven't seen, the consulting committees that the code mentions in play. And I don't know if that actually happens or not, because it seems like it would require a lot of work on the doctor's end.
Let's see, Liz, I think you were gonna start off this slide as well. When we're talking with our clients about advanced medical directives and durable healthcare powers of attorney, these are some of the common myths and fears that we hear.
Yeah, and the first one is, I'm in a car accident and I have a living will. The ER doctors aren't going to try to save me. And that's just not true. Doctors are in the business of saving lives. If I have a living will, the doctors and nurses will ignore me or won't give me pain medication to keep me comfortable. I've only been in the hospital a couple times, and I've never been in pain because they're really quick at starting off. Let's start with the pain medication first. I just don't think that would happen. And then the third one we hear all the time is that my healthcare agent will pull the plug too quickly or without consulting with me. But I believe that the doctors will try to communicate with you first. It's if they can't, if you're not able to communicate with the doctors, that they're going to talk to the agent. I had a case where I was the guardian for this woman who had COPD because she was a lifelong smoker. So she was on oxygen and it just looked very painful. And she kept telling me over and over again, I do not want oxygen. If I go into the emergency room, no oxygen. And she also had told her niece, no oxygen. So she goes into the emergency room and she's like, oxygen, please. And the niece was like, well, how can they do that? And I said, she gets to decide that she wants oxygen. She didn't realize that she would want it, but she certainly can have it.
Yeah, I think on that third bullet point, it's really, as we've been discussing among the three of us and preparing for this presentation, it's almost the opposite of, and the reality is your loved ones and family members, because this is such a difficult decision in terms of withdrawing life support or putting a DNR code in the patient's file when they can't make decisions, their own healthcare decisions. We usually see that it takes the family members or the healthcare agent. Oftentimes they make that decision, at a later time than they should, and so they actually pulling the plug too soon or too quickly. It's actually the opposite in most cases. But it's something that we hear, especially when we're meeting with spouses. It's usually because it's an uncomfortable topic for most people to talk about. It's usually the first joke that we hear is, oh yeah, you can't wait to pull the plug on me. But that's really, it turns out it's not usually the case. So Megan, can you talk with us more about how do we start this conversation?
So it's not an easy conversation to have, and especially right out of the blue. But as we're all seeing in this presentation and realizing, especially COVID brought it home to people that life is precious and you don't know what's going to happen tomorrow. So people are talking about it a little bit more. And it's important to talk about it so that you can, think about it, explore the possibilities. And there are a variety of options to get some good information, and we go over them in a few slides here. But it's important to talk about what your wishes are before the crisis happens. And for instance, COVID did change things. People who said, I would never want to be put on a ventilator are saying now, I would want to be put on a ventilator, because some people survived only because they were on a ventilator and they've resumed normal lives. So things change over time. There are lots of issues besides, do I want a ventilator? Do I want a feeding tube to give me nourishment or fluids, hydration? I had a client recently who the facility reached out to her daughter and said, now she has dementia and couldn't answer this for herself, and said to her daughter, you either get hospice or we put a feeding tube in. Those are your choices. And no one had really told the daughter that she was choking when she ate. And furthermore, they hadn't told us that, and we had not seen that ourselves. So all of a sudden, there was this big decision about, what to do. And because they chose hospice, and so the facility was willing to let her eat. And she's actually doing extremely well. They really kind of jumped the gun. But it's surprising the kinds of questions that come up and where they come from. And gratefully, her daughter knew what she would want. So she couldn't speak for herself, but her daughter spoke for her, and the outcome has been really good. The fear and concern would be that you wouldn't get what you wanted, that somebody would go ahead and make you survive without a quality of life, or that they would give up on you too soon. So you choose somebody who is going to follow your wishes. In terms of the conversation starters, there is a 4-page pamphlet called 5 Wishes. And it talks about not only the medical intervention, which is really helpful in terms of the way it's presented as a talking point, and something you can say, I found this great tool and I want to talk to you about it, to your adult children, your spouse, whomever you would want to talk about this with, your brother and sister. And it talks about the least and the most intensive interventions and everything in between. But it goes on to talk about the more personal issues, like what is comfort care to you? Is it having a massage every day? Is it just making sure that you're always totally clean and comfortable? Is it having a bath, being able to luxuriate in a bath? When, and you're really talking about when it can be in general, but end of life, when treatment isn't working anymore, you know, your days are limited, your weeks are limited, and you want something known that you maybe aren't going to think of at that time. You're thinking ahead for what matters to you. Do you want the hairs on your chin plucked? Do you want your nails polished? Do you want to wear makeup when somebody comes to see you? There are a lot of different issues. And then what do you want people to remember you by? And what do you want to say to your family when you're gone? Things that you're not going to think of at that time, but you can think in advance. And this is a really great starting point. And what Melinda and Liz have told me is that they like this tool to be used as an addendum to the official power of attorney documents that they do.
That's right. But these are really hard conversations for our clients to have. And I never know what to tell them about, you know, setting up a Saturday to have the kids over to talk about this. Do you help with this? What can we do to get them to have that conversation?
We've been brought in on a number of occasions to facilitate that conversation with kids. The kids want to know, you know, from their parents, what do you want? So we can be sure that we do what you want. And especially when the kids themselves have different values and would want different things. One person would keep the individual alive forever, and someone else would say, that's no quality of life. I know she doesn't want that. We need to let her go. And the first child just says, I can't do that. So if they know in advance, then it's much easier. And having a group discussion kind of airs it out a little bit so that it's not so quite intense. And I mean, there are things that they'll say in front of a mediator or facilitator that they won't say directly to their kids, including things like, do you have a long-term care insurance policy? And if so, where is it?
That's true. A lot of those get unused because the kids didn't know it existed.
Yeah.
A good place to put it.
We've listed various resources on this slide. Liz, I know you've used the ABA Commission of Law and Aging toolkit with your clients. I like the last bullet, the Center for Practical Bioethics and Caring Conversations workbook. Because these are very personal preferences. I mean, we can handle and advise our clients from the legal standpoint and encourage them to do the advanced care planning and to speak with their family members and loved ones. But these workbooks really help to flesh out and get the clients thinking about really what their preferences would be under various scenarios. Mm-hmm. So now we're going to dive in a bit into the legal part of it, and I'm not going to read through all the slides. There's a lot. All of this stems from the Virginia Healthcare Decisions Act, and we provided the citations to the Virginia Code, and most of our advanced medical directives, healthcare powers of attorney, very closely follow there is a suggested statutory form that we've referenced in the last bullet. And every state, most every state has their own statutory form. So you'll, even as part of 5 wishes and a lot of the toolkits we just referenced, those toolkits will include a more generic form for people to use, but our recommendation is to use the states, at the very least, the state's suggested form, because that's going to be what's most familiar to healthcare providers. Is, if you live in Virginia, you want to not use some generic advanced medical directive form, but use a form that tracks the definitions and the other terms that are used under the Virginia Healthcare Decisions Act. But the basic requirements of an advanced medical directive, a durable healthcare power of attorney, is it should be in writing. It does not necessarily have to be, but and there's some requirements, additional requirements if you want to just do it orally, but it should be in writing. It must be signed in the presence of 2 adult witnesses, preferably unrelated, but that's not required that they be unrelated. It does not need to be notarized. And generally, a photocopy of a duly executed advanced medical directive will suffice for the original. And so the first part of our document is the advanced medical directive part. And that's where you are specifying what sort of life-prolonging procedures, which is a defined term, which I'll get into in a second, and other treatment that you would wish or do not wish to receive if you're in a terminal condition. That's also a defined term that I'll get to in a second. Then the second part of the document, you appoint a healthcare agent who only has the authority to make healthcare decisions on your behalf if you are incapable of making an informed decision, which is also a defined term in the Act, which I will get to in a second as well. It's also important that the document include the HIPAA authorization so that your healthcare agent can actually get access to your healthcare information. Because most states have these statutory forms that you can download, it does not have to necessarily be prepared by an attorney. I have a preferred Virginia form that we can share also and post on our website that very closely tracks the Virginia Healthcare Decisions Act and what I just went over. And so you don't necessarily need to, it does not need to be prepared by an attorney, but ideally it should be discussed with an estate attorney as part of your overall estate plan. And this form that I provide, I think it's important to point out that a lot of people presume that if you have an advanced medical directive, that the default decision is that you don't want any life-prolonging procedures to be administered that would serve to only prolong the dying process. But I stopped presuming that was what clients wanted. And so this form that we'll share on our website, and this is how we draft our advanced medical directives, is we provide basically three, there's a range of basically 3 choices. Either the first choice, like I just mentioned, that you don't want any, if you're in a terminal condition, which again is a defined term that I'll get to, that you don't want any treatments that would artificially prolong the dying process. However, on the other end of the spectrum, and there are clients who it's their wish that they do want all treatments possible to keep them alive. So we stopped presuming that because again, it's a very personal decision. And so you're stating what treatment you either wish or do not wish to receive. So now we're going to get into the definitions a little bit. I'm not going to read these slides, but we're providing them mostly for your reference. And this again, all is under the Virginia Healthcare Decisions Act. But every adult is presumed to be capable of making an informed decision unless it's determined that they're incapable of making such decisions. And there's a certification process, as we've set forth on the slides here, that that determination that a patient is incapable of making their own healthcare decisions must be certified in writing by the patient's attending physician and a second physician or clinical psychologist, what's referred to as a capacity reviewer, who have both personally examined the patient. We state here that if the patient is unconscious, clearly it's pretty clear that they're not capable of voicing their own decisions. So that second capacity reviewer is not required in that situation. And then once.
What's the reality of this? I mean, if you're in the emergency room, two doctors aren't going to assess whether or not you're incapable of making an informed decision, are they?
Right. I think that gets back to, when you're brought into the emergency room, the doctors aren't going to say, stop. Does this patient have an advanced medical directive? No, they're going to do everything to save your life. So we're talking more about if you're then in the ICU, or if you're in a nursing facility and you're in a terminal condition and it's not an emergency room situation, that's when these certifications would be made. And they do need, once it's made and determined that you cannot make your own healthcare decisions, the Virginia Code, as stated in the third bullet there, it then that has to be reassessed no less frequently than every 180 days. All right, so some more definitions. I always cover, and we set these definitions expressly in our Advance Medical Directive and Healthcare Powers of Attorney. Life prolonging procedure. That means any medical procedure, treatment, or intervention which utilizes mechanical or other artificial means to keep you alive. And when applied to a patient in a terminal condition, would serve to only prolong the natural dying process. We have in bold here that by default, the definition under the Virginia Healthcare Decisions Act, artificially administered hydration and nutrition is considered to be a life-prolonging procedure, unless the Advance Medical Directive says otherwise. So we do have, so actually when I was saying, in our Advance Medical Directive, the first choice is I don't want any life-prolonging procedures. And then you have the other end of the spectrum for people who would want everything possible to be done to be kept alive. But we then have a second kind of middle choice. And these are, when the client signs their documents, they actually check the box and they initial what their choice is. But the second choice is for clients who feel, and there are also certain religions who feel like they if they could not take food by mouth, that they would still want to receive artificial hydration and nutrition, so long as the benefits of such treatment do not outweigh the burdens. And so, but if you don't expressly state that, having a feeding tube and artificial hydration is considered a life prolonging procedure, which which if you've indicated you don't want any life prolonging procedures to be administered, then that would include no feeding tube or artificial, hydration. And Ming is going to get into a little bit later kind of the practical considerations and the pros and cons of receiving the artificial hydration and nutrition and how that might impact the healthcare decision making. So these definitions here, terminal condition, persistent vegetative state, are also very important, and we always cover them in detail to make sure that our clients understand these terms. So if you're in a car accident and you're taken to the emergency room, unless, that doesn't mean that you're in a terminal condition and that your advanced medical directive would kick in. So terminal condition means that you're, it's there on the slide, but it's basically means it's a condition caused by injury, disease, or illness from which, to a reasonable degree of medical probability, a patient cannot recover, and the patient's death is imminent, or the patient is in a persistent vegetative state. And so persistent vegetative state is essentially you're either in a coma or you're in some other condition for which you have basically no awareness of your surroundings, and again, from which, to a reasonable degree of medical probability, there can be no recovery. And comfort care, regardless of what choice that you make on your advanced medical directive in terms of whether you want life prolonging treatment or not, if you're in this terminal condition or persistent vegetative state, regardless, most patients and clients wish to receive comfort care. They want to receive pain medication and to be kept comfortable. So other recommended provisions that we include in our advanced medical directives and healthcare powers of attorney are listed here. The pacemakers are an interesting issue. We've had several clients with loved ones who have pacemakers and did not have advanced medical directives, or if they did, the advanced medical directive was not specific with regard to whether or not that pacemaker should be turned on or off. And so it's important, if in those situations, to expressly state what your wishes are. Megan referenced the 5 wishes, and so other specific wishes you may have with regard to your personal care or treatment, or any other religious or spiritual preferences you may have, we usually either include those in the actual advanced medical directive healthcare power of attorney document, or more often we've been referencing them as an addendum. And there are various addenda, I guess is the correct term, that are available. There's one we use, or several that we use, that address clients who have dementia and the various stages of dementia, and what sort of healthcare treatment they would want or not want to receive, depending on what stage of dementia that they have. During COVID, there was this COVID addendum, which basically carved out for people who would otherwise not want to receive life-prolonging procedures, the using of a ventilator. Clearly, that helped to save people's lives during the pandemic. So that became popular. There's also various for different religions. There's various addendums that you can include and reference as part of the legal document. Also your wishes with regard to organ donation and also other final arrangements.
You
Most
know,
of our,
we don't have in here that I just realized was autopsy.
Mm.
So if an autopsy is not required, can your agent ask for one if they suspect med malpractice or some other thing like that?
right, so we usually do include the also, yeah, the authority of your agent to ask for an autopsy. And most of our clients wish to remain in their home as long as reasonably possible, so we include that. Also, the ability to transport to another jurisdiction. For example, there's various states that now allow for medical aid in dying. And so for our clients who want that option and who live in a state like Virginia, which does not currently allow for that, you're giving your agent the authority to transfer you to another jurisdiction that would permit that. The other important thing is if you've appointed your spouse as your healthcare agent, if you are in the process of a legal separation or divorce, you want to clearly, most clients would not want that spouse then to be making your healthcare decisions, so that should be included. And it's also, as a good rule of thumb, it's good to review your Advance Medical Directive, healthcare power of attorney, along with your other estate planning documents at least every 5 years.
But if you don't have that in there, that clause about separation and divorce, removing the former spouse, then the former spouse is named and the former spouse can act. A lot of people don't realize that. Only if you have that in your document can you remove the spouse because of separation and divorce.
Yeah. This next slide we're going to run through quickly because I see that we're already probably a little behind schedule. So these durable do not resuscitate orders and posts physician order for scope of treatment are relatively new in a lot of states. And well, the posts are anyway, but the durable do not resuscitate order and posts are very similar in that they are a physician's order. And so for clients and patients who are in a terminal condition, essentially this is a colored, usually a bright yellow or pink colored piece of paper that you post on your refrigerator. And so, and if you were to go into cardiac or respiratory arrest or have other trauma where the emergency medical and ambulance paramedics come to your home, they'll see that posted on your refrigerator, and that then gives them the authority that they don't, if it's stated, and that's basically the point of it, that they do not then resuscitate you, and because it's your express wish and you would not want that treatment. The posts are more recent and enacted in a lot of states, including Virginia, and cover other treatments. And again, it's for the emergency kind of ambulance people, if they're coming to your home, as to, aside from CPR, what other treatment you may want in terms of administering antibiotics and other treatment. And again, this document is to follow you. So if you're in a nursing home and you're transferred to ICU or hospital, the document is to go with you. Megan or Liz, do you have any other quick comments on posts or DNRs?
With the DNR, whether you're in your home, an assisted living, a nursing home, or the hospital, it's necessary to avoid CPR. If you do not want to have CPR started, you have to have this in it. You have to sign it, and the physician needs to sign it. And the typical place that the 911 respondent is going to look is the refrigerator door, or if you're in a facility, it's going to be the chart. So they'll know where to look. But copies are as good as the original, and you need lots of copies if you are going to the hospital from your home. You can always change your mind. If you want help and you've said on a DNR order that you don't want it, what you say always overrules that. You can always ask for more help.
One more slide on the legal aspects, and then we'll move on to the more practical considerations on how to choose a healthcare agent, and then how to actually, when you're serving as a healthcare agent, how to make those very difficult decisions. But Liz, do you want to talk about this?
Sure. This was sort of surprising to me, that if you willfully conceal, cancel, deface, rip up, obliterate the Advance Medical Directive or the DNR, then you're guilty of a class 1 misdemeanor. And if the acts above cause life-prolonging procedures to be used against the patient's expressed intent or the DNR, that's a class 6 felony with jail time. A class 2 felony, which is higher up, so more jail time than a class 6 felony, is if it's done with intent to cause a withholding or a withdrawal of life prolonging procedures, contrary to the individual's wishes. I had no idea this was in the code until I looked at it recently, and I was surprised that they have this in here. I've never heard of any cases on this, but it does give you pause, and it really makes you think about who you're choosing as your agent. Again, if they're not going to be able to do what you want them to do, don't pick that person as your agent. The duties of the healthcare agent are to undertake a good faith effort, to understand the risks and benefits and the alternatives to any healthcare. So is a second opinion necessary? Is there a way to get around surgery? Making a good faith effort to ascertain the religious values or the basic values that this person has. Are they totally against medical care? I had clients that were Christian Scientists, and we had to gear the Advance Medical Directive to what their wishes are. And they have a whole national, basically Advanced Medical Directive format that you can use, and certain language that you can put in. But if the doctors don't know that you have these, they're going to do what they normally do. And then, to extent possible, basing the decisions on the person's beliefs and values and preferences, or if those are unknown, the patient's best interests. This slide goes over the powers of the healthcare agent. And if you look at the second bullet, there's a lot there. To consent, refuse, or withdraw any type of healthcare, to employ or discharge healthcare providers, authorize admission to a facility, even against your wishes. The only thing that you can't do is put somebody into a mental health facility against their wishes, unless they've signed a psychiatric Advanced Medical Directive. And then this one is really surprising. The next point about make decisions regarding visitation. And this is only if expressly included in the Advanced Medical Directive. So if in your medical directive you say, I don't want my brother Jim to visit me, that's what the agent has to do. And could your agent do that to Jim if he shows up? Consent to participate in healthcare studies, power to commit treatment for mental health issues. Like I said, you can't really, if the person is protesting, put them into a mental health facility. And then the other thing you can't do is the sterilization or anything like that.
Yeah, so those powers that Liz just went over, again, when we're working with our clients, there are some, again, these are all personal preferences. Some clients don't want to give their healthcare agent the authority to consent to their participation in healthcare studies. Some clients don't want to give their healthcare agent the ability to essentially voluntarily commit them to a mental health care facility. So you can strike out and especially on the form, the forms that you can download. If you don't want to give your healthcare agent those powers, then you can strike through those provisions. Liz, you were going to cover then how do you go about selecting your healthcare power of attorney?
Well, it makes sense that it's someone you trust who's over the age of 18 and who knows what your decisions would be, would honor your wishes. So often I have clients that say, well, they have to appoint their oldest child because everybody will be mad. Well, no, if the oldest child isn't going to be able to handle what it is that you want, then that's not the right person. Oftentimes I just tell people that the person should have a big mouth and not be afraid of doctors, because that's the one you want advocating for you. And then Melinda and I always have this discussion about co-agents and whether we want co-agents or not. I don't want co-agents. I want one chief and then a successor and then a successor, because it's hard enough to get one person to make these decisions. To get two people to make these decisions jointly is difficult. Melinda, what do you do?
Yeah, I agree. But there are some clients who expressly want all of their children and their spouse to be co-agents. And then in that case, it's important to expressly state, do they need to all agree? Must they act jointly, or can they each act independently? If maybe one of them is not reasonably available, can the others remaining decide? Or do they act by majority? So those are all important considerations that should be expressly stated. But I agree with you, Liz. I think the decisions, these are very difficult decisions. And it's hard enough for one person to make the choice. And then when you have to get a consensus among co-agents, I encourage I encourage also to away from appointing co-agents unless the client really insists otherwise, because the buck, I think, should stop with the chief, as you said, just one person who has to make that very difficult choice.
But this does not mean that you shouldn't tell all of your family members what your wishes are. Imagine if you only told the agent and they're going in to pull the plug and the siblings are like, wait a minute, how do we know that mom wanted that? Well, it helps if they all understand what the wishes were, and one chief has to do the difficult part. And that happened with my father in the nursing home, that we heard from the doctor. We knew what his wishes were because he was constantly telling us. But my sister was the one that was the person to pull the plug, basically. And she had to be the one to authorize this to happen. And I was certainly fine with that.
We also sometimes include the client's expressed wish that their healthcare agent consult with, if they have like a trusted friend or relative or their attending physician, that before the healthcare agent makes any decisions, that they first consult with that physician. So again, these are very personal choices, and that's why you can use the statutory form, you can download that, but we spend a lot of time talking with our clients, and whatever customized, whatever their preferences are, it's best that you expressly state those in the document, the legal document. All right, Megan, now we're going to get into, with the time we have left, which we're probably going to run over a bit here. So hopefully you all can stay with us for maybe an extra 10 minutes. How do you, once you have a advanced medical directive, healthcare power of attorney in place, what should you do with it? How do you communicate with healthcare providers? And then the role that you can play as care manager when it comes to down to the practicalities of actually having to talk to the physicians and make these very difficult healthcare decisions.
Well, in regard to having the healthcare power of attorney and advance directive, it's really important that you give copies to the person that is to be your agent, your physician, your primary care physician, and have many, many copies again, so that all your doctors can have them and they can go into the system. In Virginia, there is a website where they can be placed, so any hospital can access them if you need it. Then, and as you see, it's connectvirginia.org. Some physicians are better at discussing this than others, but in reality, none of them like to start the conversation. And so if you want to know, it's really important that you ask. And I mean, the first question is, so where are we and what are the options? And the second question is, if I were your spouse, mother, or sister, what would you do? What would you recommend? And that question will usually get the most honest answer. And then the next question is, how will we know when it's time? Because people can be fighting the good fight against cancer or any other illness that they're dealing with, Parkinson's disease or any stroke, anything else. And they're fighting so hard. The question is, how do you see the tree from the forest? When is it time? And you want that doctor to be your ally in this decision. So you make that clear to them that you want to know from them as time goes on. And then you keep asking the question. The role of the care manager, as people get older, they may lose their energy, their determination, or they're sick and they're feeling frail. And it's harder to stay organized, to understand and interpret the information they're being given. And care managers are really helpful in helping them get to their doctor's appointments, understand what the doctor's saying, remind them what the doctor said, and help them follow the plan. And in terms of comfort measures and bringing in other entities like caregivers or hospice or, well, palliative care for that matter, to look at the whole person and keep them involved with their physicians for sure, but do everything else to make the end of their life to thrive as much as they possibly can until the very end.
Yeah, I think as we've all discussed and also I think personally experienced, as you just said, Megan, really the situation is going to be different and it's going to vary based on the physician you're dealing with and whatever facility that you may be in. And so again, it comes back to what Liz said earlier, that when you're deciding who to appoint as your healthcare agent, it's that person needs to be your advocate and ask these very important questions of the physicians, because a lot of them are not comfortable talking about it. And hopefully in the medical schools, I think now they're incorporating that more as part of the overall curriculum. And again, that's where I think bringing in a care manager like you, Megan, who can speak their same language and be kind of the mediator between the physician and the family members can be extremely helpful. I know, Megan, you used this book and you've given us copies. Can you just talk a bit about Hard Choices for Loving People by Hank Dunn.
So it's really hard to make some of these decisions for yourself without really understanding the ramifications. This book is really helpful because it offers a number of facts. And it was written by a chaplain, a hospice chaplain, who recognized in his conversations with people how difficult these decisions were. So, for instance, one of the facts it talks about is it was CPR in a hospital setting. Only 17% of the time does initiating CPR result in the person going on to live. And another really interesting fact is that when a person has more than one, an older person has more than one underlying condition, that they're very unlikely to respond to CPR. So the flip side of that is it's very easy to crack bones, totally unintentionally, obviously, but those fragile bones and then puncture lungs and other organs. So tremendous pain can be experienced while somebody's trying to save you. So I mean, that's a whole other issue. If you're not going to respond and live, happy days after that, do you want the CPR started? And in terms of feeding tubes for nutrients and hydration, when somebody's body is really dying, when you're really at the end of life, adding nutrients and fluids really doesn't help. Your body doesn't use it anymore. So when a person has decided that they simply do not want a feeding tube, it is much easier to go with their wishes when you recognize that it's not going to really provide real help anymore. And the other thing that this booklet does is it provides a lot of detailed information about what is palliative care, which is treating the symptom, not the disease. So it's not trying to help you get rid of the cancer. It's trying to help you deal with the palliative care physician or provider would help you deal with the nausea, the pain, the difficulty getting good nourishment after colon cancer treatment. I mean, a whole series of things. It could be anything, but it's treating the symptoms, not the illness. And then comfort measures, and then hospice. When is it time? What does that look like? So you're usually talking to your physician about what treatment options am I talking about, or when do we stop that treatment? But in addition, there are all these other options out there for you. It doesn't just stop with stopping a treatment.
And we also referenced another very helpful resource there, which I actually just heard speak. This Dr. Morhaime, very interesting perspective he offers. He was the ER physician and also served in the Maryland state legislature for like 24 years and has strongly advocated that everyone should have an advanced medical directive. And not only you should make sure that you have one, but you should ask all of your loved ones, do you have an advanced medical directive? And so I would also highly recommend his book as well, which we have listed there. So this is our last slide, and just some final considerations, especially coming out of the pandemic, which, as Megan said, really has brought awareness to a lot of people about the importance of advanced care planning and making sure you have an advanced medical directive. I've already had mentioned there are currently 11 states who have enacted these medical aid in dying statutes. We have them listed here. I heard Dr. Morhaime when he spoke recently. He said a lot of people wish that they would be afforded the same dignity that their pets are afforded when it comes to end of life treatment. And so these 11 states, DC most recently, that's an option. I think, Megan, you were going to talk a bit about this whole new kind of other resource and role, death doulas and how they can assist?
So the death doulas really understand and believe in the importance of all of the beliefs and the rituals that go along with someone's spiritual life and their family. And so not only are they looking at comfort, but they're looking at how do you want to celebrate your life with your family, your loved ones in those end days. And they're very skilled at asking the right questions and making sure the right care is involved. There are some care managers that are actually also doulas. We had a client recently who, it was one of the hardest deaths I've ever seen. She was 78. She was very with it intellectually. She was very bright, very brilliant. She had been fighting cancer for a couple of years, and it came down to the end where nothing was going to work anymore. And she had done absolutely everything. And so here was this very cognitively alert person that was settling in to die her last days. And I wish that we had had a death doula with her, because we had a series of caregivers who were well-meaning, but it was very hard to relay each shift to the next person, which what she truly wanted. And this is a woman who wanted to wear makeup when anyone was in the room with her. She wanted her hair in a beautiful hat because she'd lost most of her hair. She wanted lotion on her skin every day. A death doula would make sure that that was done. And next time in this same situation, I'll bring in a death doula for a scenario like this.
I had some clients tell me that when their parent died, all the family was there in the hospital, but nobody was talking or anything.
Mm-hmm.
And this death doula came in and started asking questions and asking stories. And it wound up being a really, really nice death.
Yeah.
It's a peaceful death.
All right, well, we are now just about 10 minutes past the hour. Liz, did we have any questions that came in?
No, but our colleague Angela Baker, who is an attorney as well, mentioned the difficulty approaching the need for advanced medical directives by attorneys if you're not considering the emotional and psychological issues. And then when she was a financial advisor, she facilitated family conversations. And it was easier for Angela to ask these tough questions rather than family members.
Good point. And I think, yeah, that gets back to our main message and why we wanted to host this webinar in honor of and the whole point of National Healthcare Decisions Day is make your wishes known. Because again, it's going to make it easier for your family and whoever is going to be making those very difficult decisions, end of life decisions, that they're not guessing what you would have wanted, and more importantly, that they're not fighting over what you would have wanted during what is already a very difficult and emotional time. So with that, we thank you all for joining us. Liz and Megan, do you have any final remarks before we sign off?
No, I think we said it all.
All right, we'll do our best to get to post the recording of this webinar along with the slides on our website, and check back in a couple days, and we'll also share on our firm's LinkedIn and Facebook page when those become available. And thank you all for joining us.
Thank you.
Thank you, guys.
Thank you.